Hi, I'm Jonathan Cappy.
And I'm Amir Abdul Qadir.
Welcome to Holland Estates. You're listening to episode number 537. Today, we will be discussing some informality in estate procedure.
It's true. We'll also be discussing that in the context of a family dispute,
Yes.
which is always a pleasant topic around the time of the holidays.
So we all know that there is a lot of formality in the rules of civil procedure. In particular, we're going to be talking about limitation periods, standing, things that are very structured and have very specific procedures in terms of starting claims, originating processes, things like that.
Mm-hmm.
But there are times where it can be less formal. It just, the way the process unfolds in order for the parties to address their issues in an efficient manner. And Rule 1 provides for dealing with matters in the least cost determination of the issues. And sometimes the procedure can also pick up in that way.
Right.
And so the case that we've got in front of us deals with one of those instances.
I agree, and those procedural facts can become very important when it comes to assessing whether a limitation period has expired or whether it's been told. And I think this case perfectly illustrates that. It's a recent decision by Justice McEwen of the Toronto Court. And I can give a bit of factual background here. It's a long-standing dispute. Essentially, there was a property that was jointly owned as a rental property or an income property by grandparents, one of their grandchildren, and her spouse. At some point, that relationship turned sour, and there was litigation commenced by the grandmother following the death of her husband in 2009 to force the sale of this property. One of the issues that was lingering in the background, it appears to have lingered in the background from the very beginning, were services that were being rendered by another grandchild who was allegedly providing property management services. And this particular decision arises out of a motion that was brought by that grandchild, who was a non-party to the application, for compensation as the property manager for this property. The interesting thing here is this application was commenced in 2009. The grandmother, who it appears from an early stage in the litigation, had denied the right for this person to be compensated for these property management services, had passed away in 2012. And of course, this was coming before Justice McEwen several years later, yes, in 2017. And so the two preliminary issues to be determined by Justice McEwen was whether this grandchild who was making a claim for compensation had standing, given that they were a non-party, and the other issue was whether their claim for compensation was statute barred either by the 2-year limitation period under the Limitations Act or the 2-year limitation period under the Trustee Act.
That's right. So I think that it is clear and accepted by everybody that by the time it gets before Justice McEwen, we'll call him the property manager, whether he turns out that he's to be compensated or not. I think it's clear that he was managing the property.
Right.
So it is clear that he had not commenced a proceeding. Mm-hmm. Okay? So we get to the point now, we are now years and years after he made this allegation that he was entitled to compensation. Certainly well more than 2 years passed when the deceased passed away. He has not started a formal proceeding. The first question the court wrestled with was, does he have standing? Right. This was originally an application commenced by the estate or by the deceased and then continued by her estate as against a grandchild with respect to selling this property. This property manager was not a party.
No.
Okay.
And this is where the procedural history becomes very important and very interesting, because Justice McEwen then goes on to look at prior orders and endorsements that were made in the application. And so there was an order back in 2009 identifying the property manager as the property manager. There was a subsequent order by Justice Patillo in 2012 that ordered that the issue of compensation would be dealt with when the property was sold. And in fact, the property was only sold in 2017, 5 years out, almost 5 years after that order was made. The endorsement was was made, and then there was an endorsement requiring the property manager to account for the duties that he had performed, and there was also an order that provided the procedure for this non-party to bring his claim for compensation to the fore. And these orders and endorsements, which spanned from 2009 to 2016, were on notice to the estate, the deceased,
yeah.
and subsequently to her estate trustees.
So, notwithstanding they've been involved throughout, now in 2017 they're taking the stand and said, well, you don't have any standing.
Right. And it appears, at least based on the record that was before Justice McEwen, that at no time did the estate previously take that position when these prior orders and endorsements were being made.
And in their defense, the estate trustees said, listen, when we were dealing with all of these issues, I was more focused on the other things, with respect to the sale of the property, ownership of the property, whatever it was, and I wasn't really focused on this property management claim. Mm-hmm. And the court said, listen, I'm sorry, but you were here, these issues were getting dealt with, it was front and center, and so now it would be inequitable for you to say that he doesn't have standing, since he's been pulled along this proceeding for the last 7 years. He was providing property management services until recently, and it would be inequitable for him to argue that you have no standing at this point.
Right. Justice McEwen concluded that they were stopped from making this argument about standing, and also concluded that this was essentially a collateral attack on those prior orders, which were on notice to the party that was now seeking to argue the issue of standing.
So the more interesting part of this thing is the next issue.
Limitation periods.
Yeah, and not so much the Limitations Act, because that is, when do cause of actions arise, and I find that to be, normal on the facts when it's discoverable, and there was a letter sent that was not unequivocal, and the court said that it wasn't discoverable. The real interesting one I find in this particular case is whether or not the 2-year Trustee Act from date of death has expired.
Right.
Because we are certainly now, by the time this got before Justice McEwen, we now know that no proceeding was commenced by this property manager, and 2 years has now passed since date of death. So is the limitation period expired, or has a claim been commenced? So this is the part where we start dealing with more informalities in the commencement of a claim.
Right. And it was a really interesting discussion, and it happens starting at paragraph 28 of Justice McEwen's judgment, a link to which we will post with our podcast for our listeners and viewers. Essentially, the issue here became, well, more than 2 years had passed, had the limitation period expired. And as I previously mentioned, there was an order from Justice Patillo back in 2012 that specifically provided that the issue of compensation would be dealt with after the sale of the property. And the property sale had only happened in 2017. So almost 5 years had elapsed, and now the issue was, well, is he now barred from bringing this claim forward? Or
So he was told by Justice Patillo, just wait your turn, let's deal with the sale of the property, and then we'll address whether or not you have a good claim or not. Well, we'll address the merits of your claim, is what Justice Patillo was saying. Mm-hmm. And now, 5 years later, they're saying, well, you never started your claim, I think you should be at a time. Basically, what McEwen said was that because you were recognized as having this claim, notwithstanding you haven't commenced a formal claim, you have started your claim.
Right. That's essentially what Justice McEwen concluded. He said, well, Justice Patillo's prior order conferred standing on you, and by making this an issue to be determined after the sale of the property, it obviated the need for an originating process.
Yes.
So normally, this property manager would have been required to formally commence a claim seeking recovery of these funds, but by ordering this issue to be determined, Justice McEwen basically concluded that
What the words he
there
used
was
were
no necessity.
that the previous order effectively dispensed with the need for originating process.
Right.
And so that takes us to the practicality of ongoing state litigations beyond this particular case. I don't think we can make any blanket statements. This is the first time that I'm aware of this having been raised. But if, you have suits and countersuits in an estate, whether it be a will challenge with other claims, is there a need for the responding party to start their own application and assert claims in an independent action in their own originating process? Mm-hmm. Or can the parties agree on an order giving directions which acknowledges each of the claims going back and forth, and is that sufficient to dispense with the need for an originating process, as Justice McEwen says.
Right. It's an interesting issue, and I mean, I can think of hypothetical scenarios where, it could lead to ambiguity. For instance, a judge might say that a certain issue needs to be determined, let's say compensation, but is it just the monetary compensation? Or does such an order need to speak to potential other claims that the property manager could have? That didn't really happen. This discussion didn't happen in this case. But let's say the property manager had other potential claims, such as equitable claims. Would they have also been saved by this particular process? It's a question that I think would be fact specific on, and it wasn't something that was really an issue here. But it certainly raises interesting questions about, limitation period issues, and when a situation like this arises, that informality can kind of create uncertainty amongst the parties.
And it's and if you are thinking about using or giving directions as your originating process, you might want to make sure it's somewhere clear in the order that the need to commence an originating process is dispensed with by virtue of it, because certainly you don't want to take that risk, but you want to make sure that you're if your order giving directions puts that issue before the court, that you are now having commenced it formally.
Right, but I think in this scenario, it was clear to the court that it would be unjust to allow the co-owners to benefit from the amount of time it had taken to sell this particular piece of property, and it would also be unjust to allow the estate, who had participated in this proceeding throughout, to now benefit from not raising the issue of a lack of originating process when the issue of standing was first determined. So I think ultimately the court was trying to reach a decision that was fair based on the procedural history that had occurred in this particular case.
Great case, fascinating decision, and further reaching ramifications. I think something for everyone to think about.
For sure, and an important reminder to really be mindful about, for parties to preserve any position they may have on a particular issue, even when just dealing with directions or procedural issues in the course of litigation, because something like this procedural order ultimately was found to have commenced a claim with respect to the payment of property management fees. So it's an important consideration even in early stages of litigation.
So I think that concludes our podcast. Until next time, thank you for listening. I'm Jonathan Cappy.
And I'm Amir Abdul-Qadir.
Should you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog. Have a great day.
Thank you.